All right, buckle up. This first case is a classic tug-of-war between redemption and reality. Ashley Faye is walking the razor's edge. A 5-year cap sounds like mercy, but that PSI report, it's full of red flags. Jail trouble, denial, and a history that keeps looping back. Let's see if her plea for treatment outweighs the state's push for punishment.
And Ms. Faye was previously in court, entered a plea of guilty to the third-degree felony offense. Well, and it was a state jail that was enhanced to a third degree of credit debit card abuse. The agreement was for a cap of 5 years. And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor.
Are there any additions or corrections?
Just a comment as to what Ms. Faye's comments were, Judge. It appears that she's not taking responsibility. I spoke with her about that. I think
I was just kind of confused the way it was worded. I didn't know I was never really truly told like the specific on the case. Like,
Did you use somebody else's credit or debit card?
it was me and my friend did.
Okay.
And I didn't understand how she worded it.
Okay,
But yes, I did.
okay.
that's the only correction I had, Judge.
Any corrections, Mr.
Nothing that I
Nichols?
saw, Your Honor.
Also, in addition to that report, I have received looks like a few pages of jail incident reports that I've reviewed as well. Has everyone received those?
We have, Your Honor.
All right, you may.
Quick legal insight here. When the judge probes about whether Ashley used someone else's card, that's about establishing mens rea, her intent. The difference between confusion and deliberate fraud can decide whether she gets help, or handcuffs. What do you think? Genuine confusion or selective memory?
Proceed with the argument.
Yeah, Judge, I think looking at her criminal history, it doesn't scream that this is somebody that deserves a chance on probation. That's what she's asking for, however. If you look at her comments on page 4, she's asking for Santa Maria. We've already talked about that a little bit this morning. She's indicated to the probation officer that she doesn't have an issue with drugs. She wants to go to Santa Maria for, I guess they've got a kind of like a cognitive track there also. But obviously, looking at the PSI report and everything that's in it, if they can give her help with drugs there, then that's certainly something that would be beneficial to her. She's ready, I think, to stop going to prison. She's realized that that's not something that she wants to continue to do. She's put herself in that position again today. But speaking with her, she's really ready to turn her life around. And regardless of what you do here today, Judge, she's asking for probation, but even if you send her to prison, I think she's made up her mind finally that this will be the last time that she comes into court for any kind of felony offenses. She's really hoping that you would give her the opportunity to go to Santa Maria and get that the tools that she needs to make the better decisions in her life.
When did you get off parole?
January.
January of this year?
Yes, ma'am.
So you committed these offenses. You got off parole and you thought, let's do it.
Actually, Judge, the offensive date predates her.
Oh, so you were on parole. There we go. I was looking at that possession of controlled substance that haven't been filed. So you were on parole.
Notice how the defense pivots from excuses to transformation talk. That's a classic mitigation move. They're not denying guilt. They're painting a redemption arc. But here's the tension. This isn't. Her first act, the judge has to ask how many wake-up calls make a pattern.
Mr. Nichols?
Judge, I'd urge the full range of the cap based on her criminal history.
Bless you.
In addition to the state jail priors that are listed in the indictment, there's also a burglary conviction.
Yeah, she got 7 years. That's the one she
That's
was on
correct.
parole for. So you've been convicted of a burglary of a habitation, a theft of a firearm, previous theft, got probations on all of those, even at different times. It looks like you were on probation for the burglary and the theft of a firearm, and then someone, potentially me, I don't know whose court that was in, but here, left you on probation and gave you 2 probations. on those new thefts, and then you violated all that after getting those, and now you're here. Okay. All right, Ms. Fay, okay, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of credit or debit card abuse. Find those prior offenses, convictions true. Going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You're lucky that you got the cap, Mr. Rojas.
And there it is, 5 years. The maximum under her plea cap. Let's unpack that. The cap doesn't guarantee leniency. It just sets the ceiling. The judge's tone says it all. Mercy has its limits. And when you've already burned through probation after probation, that limit comes fast.
Did a good job. It's rare that you're going to get rewarded for more bad behavior. You already got a 7-year sentence. You probably should be getting worse than that instead of going down. So you will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
All right, this is cause number 25, DCCR 0304. And are you Gerson Santa Maria Mendoza?
Yes, ma'am.
Mr.
Oh, now watch this pivot from a repeat offender. Facing consequences to an 18-year-old standing at the very start of adult punishment. This next case isn't just about crime, it's about potential. One misstep, and Gerson Mendoza trades his second chance for a life sentence.
Mendoza was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. The agreement was for a 10-year deferred probation and a $1,000 fine. I've received the pre-sentence report. And has everyone had an opportunity to review that report?
Yes, Judge.
Are there any additions or corrections?
No.
Not from this day.
So, Mr. Mendoza, you're only 18, is that right?
Yes, ma'am.
All right, so if I'm going to follow this agreement based on your age, the nature of the offense, the fact that you withdrew from school and haven't completed high school, I'm going to up front send you to the program called ISF. It's a 90-day program, and it is intended to help you to make better decisions. Because of your age, obviously, I want you to be successful on this probation, but I think there needs to be some involvement by other people to help you do better. Does that make sense?
Yes, ma'am.
So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. That's including going to and successfully completing the cognitive track of the ISF program.
Okay.
If you do everything you're supposed to on this probation and you successfully complete it, This is a great opportunity because you don't have a conviction for a felony on your record. The other side of that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty, so you would be a convicted felon, and you could go to prison for anywhere in the range of punishment, which is a minimum 5 years up to the rest of your life in prison. Do you understand? Also, a condition of your probation is going to be that you get your GED. So once you get out of ISF, you're ordered to start that process within 45 days. Okay. All right, I'm handing you the trial court certification.
What a contrast, right? One defendant learning lessons too late, another getting a rare shot before it's too late. This is what sentencing really tests, not guilt, but growth. So here's the question for you. Should mercy depend on age or on attitude?
That shows that this was an agreement that I followed, so you waived your right to appeal. Okay, good luck to you, sir. Thank you, Ms. Burge. Thank you. They might. You can let them know too. You might be able to start your GED in ISF. So check into it.
Because TDC does have a good